been solely and wholly dedicated to doing VC transactions and other corporate transactions. And I thought it's a good idea to share some insight into how VCs function, how VC transactions happen. And that's what led me to this presentation, essentially. I wanted to basically, the idea is to basically familiarize the audience to the concept. I don't want to go into too much depth and sort of make it an inefficient process for everyone out here. I want to basically tell people the concept so that they understand the concept, and then you can go about doing a deep dive into it by reading more material on it, etc. Or we could do more presentations on each topic or each concept in itself, because each concept is a separate presentation material. Now, having said that, I'm just going to begin my my presentation. It's I have about, I think, an hour or so to sort of present. And at the end, we'll have about 30 minutes for questions. So please note down your questions and sort of feel free to ask me whatever you want to at the end of the session. And I'll also pause between each slide to basically take questions. If you want me to emphasize on something more, or you want me to explain something in a little more detail, we could do that as well. Now, having said that, I'm just going to sort of share my screen and start the presentation. So the topic is as follows. I'm basically going to focus on one aspect of venture capital, that is basically key concepts and subscription agreements. As Vikas was saying, I will do a presentation, I'll do a second part of this again, and that will basically focus on concept under the shareholders agreement. So in terms of what I've put together for this presentation, one is understanding the basic concepts and common terms in a subscription document. I've also sort of want to introduce and speak a little about what is a venture capital investment in itself, and then go on to explain what is a share subscription agreement and how that investment happens. The second part of it will be on the regulatory framework, basically a little bit of legalese for those who want to understand the legal framework that's applicable to share subscription. And finally, we will be breaking down a share subscription agreement. So we will be basically breaking it down and understanding the key concepts. That's very common in a share subscription agreement. So that's what we're going to do. Okay, so I think the first question that everybody is going to have is, what exactly is a venture capital investment, right? So venture capital investment is basically an investment, as the name itself suggests.
Amrita, probably you have closed the video, your face is not coming forth. Or it's your choice.
Yeah, I just want to make sure that the screen is clear in terms of the presentation. I'll get the video on when the questions come on.
Right.
Yeah. Okay. So basically, a venture capital investment is an investment that is made by a venture capitalist into a company, right? So there are about 4 things you'll have to remember. First of all, that it's money that's flowing into a company, and then that money flows in through subscription to shares. Okay. So why will somebody give money to somebody else? And the simple answer is they want to do it because they hope to get a return at the time of exit. So if you break it down, every company that sort of, every promoter that runs a company, and every company in order to run its operations will need funds, right? The most common way to do it is either you do it through debt, which means that you go to bank, take a loan, and take that route. And that's a secured debt. Or you do it through taking money from venture capital investors or private equity investors. So these investors typically, and by definition, they're not meant to be. It's not meant to be a debt investment. It's supposed to be an investment into the share or the capital of the company. So they put in money, they get back shares in return, and they sit in the company for a window or a period of time, let's say 5 years, sometimes 6 years, 7 years, to make sure that they get an exit on that, make sure that they get a return when they sell off their shares finally. So essentially they come into the company, put in money, get shares, and when they go out, they sell their shares and make money on that particular investment. So that is what, in short, is what a venture capital investment is. Now, there are some terms, mostly these are not legal terms, these are more commercial terms that people use. in venture capital deals, and that I thought it's useful for the audience to know what these terms actually indicate. The first concept is you must have heard a lot of people say seed investment, Series A investment, or pre-Series A investment, or Series B investment. So what is this series? So essentially, when a company has just been incorporated or has just been set up, right, and you need funds at a very early stage, you go to investors and try to raise funds. That type of funding is called seed funding. It basically is for very early stage investors and very, very early stage fundraise. Series A is a more sophisticated sort of round. Typically, seed rounds happen with angel investors, friends and family. You could go to a bunch of people who are not necessarily institutional investors. Sometimes institutional investors like funds also participate in seed round, but mostly it's the angel investors basically mean individuals, prolific individuals, promoters of other companies, individuals at a high net worth who basically want to invest in another company. So that seed round usually happens with those kind of investors. Series A typically means that you've got an institutional investor on board, meaning you go to a fund, you go to either a Sequoia Capital or a Chatrath, or you go to, there's so many funds that you can speak about, and each fund has its own vision on what type of investment they make. So essentially, Series A indicates that there's been, there's basically an institutional investor on board. Now, when you capture it in the document, you also call, depending on the type of investment that's happening, the shares are also classified accordingly. For example, if there's a seed investment, you call, typically the nomenclature that you use in the document also would be seed shares. If you do Series A, you will say Series A shares. Now, Series A, everybody understands is institutional. Series A onwards, everything is institutional. It's usually the institutional guys who come in. So what happens after Series A? What is a Series B? So every time investment comes into a company, the company needs to be valued, okay? Because you're going to basically get shares, right? The obvious logical question is, at what price do you issue the shares? How do you determine that? Determine what price will be paid for that particular share, and that is done through an exercise that's called valuation. Okay, and it's also a legal requirement, and I'll touch upon that a little bit later. But it's also something that a lot of investors do to value the company. And if there is, so Series A, let's say the price is 50 rupees a share. I'm just giving you an example. It's usually higher. If you're raising after Series A next fund, next round of fund, and in that next round of fund, your valuation is shot up. And if your price is, the price of share will be per the valuation is 70 rupees. Typically, there's a difference between Series A and there's a difference between the next series, right? That's why you term it as Series B. So each series basically means that there's been a new investment in the company, and the price of the share has changed also accordingly. And that's how you call it a Series A investment, Series B investment, and so on and so forth. And if you have Series A, A1, A2, it's basically investments that have happened at different points in time and as part of the same larger fund raise. So it's part of Series A, but let's say one investor came in now, issued shares. Then after 2 months, let's say another investor sort of invested in my company at the same price at which the Series A guy came in. I'll probably call it a Series A1. So that's how people use nomenclature, and that's the basic simple logic behind the use of these terms. The second aspect is pre-money valuation and post-money valuation. This is something that a lot of people, you will see in a lot of term sheets, you'll see in a lot of venture capital deals, people keep sort of using this term. And what does that mean? Pre-money basically means before the investment happened. Pre-money is before the money came in, post-money is after the money came in. So before the money comes in to the company, like I said, you will undertake the valuation exercise. Whatever value you attribute to the company before the money is put in, that is called a pre-money valuation. And depending on the pre-money valuation, you arrive at the price per share. So that's a little bit of mathematics there, but that's how it's done. And once the money comes into the company, once you've put in your investment, you add the investment amount to the pre-money valuation, and that becomes your post-money valuation, essentially. I want to pause at this time and just ask if this is clear, if anybody has any questions, or should I just sort of move on? Okay, so the next thing is what type of shares are usually subscribed to in a venture capital deal. Like I mentioned, this venture capital investments are meant to be straight equity, meaning it's not a debt deal. It's not a deal where you typically see debentures or anything of that sort. You see shares, and people, because they're coming in and they're paying a price for a higher price for the shares that they're investing in, they usually get issued CCPS, which is basically preference shares, convertible preference shares. And the logic is simple. Preference shares usually sort of give you a preferential right in terms of dividend and also at the time of winding up. That's something that all of us know. The other thing to remember is it's also important for the investor to come in, especially those of you who are young lawyers here and want to understand this. When investors come in and when they want to subscribe to shares, it's usually done through a combination of shares and straight equity shares, ordinary equity shares. The reason for that is, it's predominantly preference shares, and you probably have about 10 or 15 equity shares. The reason for that split is simply because you want to make sure that you get the benefits that is prescribed in the Companies Act for ordinary shareholders, as in, because preferential shareholders, their right to voting, etc., is slightly different. So you want to make sure that you get.
Amrita, people are saying just be slightly slow in the pace.
Okay. Essentially, I was basically telling you about the combination that they use, right? So if you want to, people usually do a combination of equity and preference shares. And the reason is because they want to get the benefits that is attributed to ordinary equity shares under Companies Act. So they want to be invited to meetings that do not affect just the preference shareholders, but also the equity shareholders. So that's why it's usually done that way. It's done in a combination, and that's something that people should recommend to their prospective clients. And it's usually just about, even if you have 10 or 15 equity shares, that's enough, because that just gives you the basic rights of that are given under the Act to ordinary shareholders. So that's basically about venture capital investment. The next concept is what is a share subscription agreement, right? Because we're going to speak and understand share subscription. Now the investment is coming to the company, and I mentioned that this investment is done through subscription to shares. Subscription basically means where the company is issuing fresh shares to someone or to the subscriber, okay? And obviously, because you're paying money for it, and there's a lot of money that's paid in these venture capital deals, you need a document to document that understanding that's there. So that's why you have a share subscription agreement. It's a document that documents the understanding between the company and the investor on the terms of subscription. And the key terms would basically be what type of shares will be issued, the number of shares, the investment amount, what's the price per share, what are the representation warranties and covenants based on which the investment is made, and finally, when will the investment be made, and how will you go about issuing those shares. So that's all. That's the whole soul and crux of a share subscription agreement. There's nothing more to it, and of course, it runs into a lot of pages. But it's, in my experience, it's always important to understand. If you understand concepts, you'll be able to sort of break it down and sort of find your way through those pages without a hassle. I'm going to move to my next slide, which is basically regulatory framework. At this point, if there's any clarification you want on this slide, or you want me to explain another concept, let me know. I'm just going to pause for about a second or so to see if anybody has any questions.
We are unmuting Anubhav. Anubhav, you can post the question, or you can get yourself unmuted.
Hello.
Yes, Anubhav.
Good afternoon, ma'am. So my question is that you told us that VCs usually take their capital in the form of majorly 80% in preference and the remaining 20 in equity. So can you explain the rationale of that again?
Yeah, so it's basically 99% in preference and 1% in equity. So let's say an investor is subscribing to, I'm giving a very small number, okay? Let's say an investor is subscribing to 100 shares in the company and has made an investment. So he'll probably buy 90 shares, 90 shares of that will be CCPS, that is basically preference shares, and 10 will be equity. Now, under Companies Act, preference shares basically mean that you get preferential dividend and you're treated in a preferential manner at the time of winding up. But as a preferential shareholders, your rights are also slightly limited under the Companies Act, meaning you cannot vote on things that do not concern you as a preference shareholder, right? Things like that. Whereas an ordinary shareholder has a wider ambit of rights under the Companies Act, which is why what they do is to make sure that they get the best of both worlds. They sort of subscribe to preference shares, and they also subscribe to some very nominal equity shares. Does that answer your question, Anubhav? Okay, I think you're on mute.
Hello. Yes, ma'am. Ma'am, majorly. Another thing, you told us that preference shares and equity shares are separate. I understand that much. But are they issued on the same price?
Yes. Yes. It's the same price. You don't have different pricing for it. It's essentially the same price because you would have done your valuation and you'll have to basically issue it at the same price.
All right. So the seed investment and for institutional investors, it is the same.
It's no. Seed investment is a step before institutional guys, right? I mean, essentially, whoever is participating in one round. Let's say you're the company, you're the promoter of a company, and you're raising funds today. Let's say I'm an investor in the company, and let's say Vikas is also co-investor with me, as in he's investing at the same time. So if both of us are investing at the same time, we will do a joint valuation of the company. We'll arrive at a price and we'll pay you the same price. Okay. But let's say after me, your friend, let's say Mr. X, okay, he's also an investor and he invests after us, after Vikas and I invested. So his will be a different series. At that time, you'll run a valuation again and the price would have significantly gone up, right? So that will be a different series because the price has gone up. So he'll pay a different price because he came in after us. Essentially, every time you invest in a company, the post-money valuation changes because you would have added the investment that already comes into the company. So the new guy, whoever comes in a little later, will have to pay a slightly higher price.
Understood. So, ma'am, as far I know, I'm asking a lot of questions, right? I'm sorry, but this would be last. I will.
Sure. And you have 30 minutes later also to ask me whatever you want.
All right. So my limited understanding is seed investment is just the series investment, but by the families and friends and relatives, right?
Yes, it's Series A typically means Series A comes after seed. Okay. Seed is basically the first investment that somebody makes into the company, and it's at a very early stage. So you would have just about incorporated the company. And at that time, you don't have much to show to your investors to build the valuation, right? So you go to your friends and family, or maybe you'll go to an individual, like a high net worth individual who wants to invest, and you probably get investments from them. That's called a seed investment. The series that come after the seed investment is basically called Series A, Series B, and so on and so forth.
All right, understood, ma'am. Thank you so much. Now things are crystal clear.
So, madam, I have one question. See,
yes.
Normally in most of the cases, the investments happen at a premium.
Yes.
So, in that being the case, why investors don't subscribe to equity shares with the premium sitting as share premium account? Why they always insist on the whole thing to be a convertible preference shares? Any reason is there?
Okay. A preference share, if you look at the way preference shares are structured, they come with certain rights, and these rights are in the nature of anti-dilution rights. There are liquidation preference rights, right? I'll go a little more into detail about it in my next sort of session, because essentially they want to get preferential treatment, and as a result of which there are some preferential treatment that's under the law, and there's something that's drafted contractually. We cannot do that with an equity share, right? So we usually do that with preference shares, and we put it out there saying that there are some contractually agreed rights that are associated with these preference shares, like liquidation preference, etc. And that's the reason why they usually like to do this preference share option.
Okay, thank you. I got a question I will ask at the end of the session. Please continue.
Okay, I'm moving to my next slide. So now the regulatory framework. Anyone who wants to review a share subscription agreement has to basically familiarize themselves with three primary laws, and they fall under the three buckets. One is Indian Contract Act. The second is Companies Act, and the third is Indian Exchange Control Regulations. Now, why Indian Contract Act? Because at the end of the day, your SSA is a contract, it's an agreement, and And the principles that apply, the general principles that apply to any commercial contract will apply even to the SSA. For example, and this we'll do more in detail. I haven't put out too much notes here because we'll do it in the next slide where we actually break down an SSA. And you'll understand the concepts of Contract Act that apply there. But just to give you a flavor of it, there are concepts such as indemnity, there's a concept such as representation, warranty. All of these are concepts that are flowing out of the Contract Act, and the remedies that are associated with them, the way it should be drafted, etc., is all flowing from the Contract Act. So anybody who wants to understand SSA should first of all read and be familiar with the Contract Act. The second thing is Companies Act. Okay, why Companies Act? Because you're issuing shares, and any issuance of shares is basically regulated under the Companies Act. And very normally, the Companies Act compliances are put out as conditions to the share subscription agreement. Essentially, you will say that you have to pass so-and-so board resolutions, or you have to pass so-and-so shareholder resolutions to approve issuance of my shares, and to basically make sure that the entire process of issuance is complete. There'll be some filings that you'll have to do with the Register of Companies, and there'll also be issuance of share certificates. So these are broadly, there are only these three categories of compliances under Companies Act for the limited purpose of subscription. Okay, and the third category is your exchange control regulations, and this is basically under FEMA. Okay, I'll explain a little bit about the framework that applies here. Why does FEMA apply? FEMA is basically Foreign Exchange Management Act. It was introduced by the central government in 1999, and it was basically introduced to regulate money that comes into the company and money that goes out of the company. So if you goes out of India, sorry, not the company, money that comes into the country and money that goes out of the country. So under FEMA, there are two key concepts. There's one, capital account transaction, and there's two, current account transaction. All investments, etc., come under capital, are categorized as capital account transactions. So the government needs to know who is sending money into the country. So that's why they've come out with rules and regulations to basically regulate that aspect. And you'll have to also make filings to make sure that they know, that the authority knows that so much money is coming in. And if you're making, similarly, if you're making investments outside of India, that's when there are other regulations that apply as well. And you just have to make some reporting requirements. There's some reporting requirements to ensure that the government keeps a tab on how much money is also going out. Now, to understand FEMA, you first have to read FEMA. Under FEMA, the RBI and the central government have both been authorized to issue regulations and rules. Okay, and that's how you have all these RBI regulations. I mean, those of you who are familiar with this side of practice, you would have seen the master circulars that used to come out before. Earlier, what used to happen is the RBI, every July 1st, they would come up with master circulars on, and each master circular would regulate one particular aspect. For example, there's a master circular on foreign direct investment into India. There's a master circular on outward investment outside of India. There's a master circular on export and import of services, right? So there are different types of master circulars. Now, what happened last year is the Ministry of Finance issued the non-debt rules, what we call as the non-debt rules, and that's essentially what was previously covered in the master circular for foreign direct investment with some changes. So as on date today, that is the rule, that is the regulation that you'll have to look at if you want to understand the FDI, or basically foreign direct investment into India. And the second thing to know is, why is this relevant? Because most of your institutional investors, I mean, there are two types of investors. There are investors who are residents of India, and there are investors who are not residents of India, and they're basically foreign investors, right? So for every time there's an investment from a foreign investor, most of the institutional funds are set up as funds and are set up outside of India. So money comes in from outside, and that's when FEMA and the provisions of FEMA become applicable. Now I'm just going to break down three concepts that you should keep in mind for subscription purposes under FEMA. One is the FEMA, the regulations under FEMA, the non-debt rules currently that are in force, basically speak about different sectors. So for example, there's manufacturing sector, there's ITES, there's pharmaceutical sector. And each sector, the rules will tell you if that's in that particular sector, investment is allowed without government approval, or it's allowed with government approval. So there's first, you have to check that box to see if the sector in which the company is operating in is basically something where in foreign direct investment is allowed without permission, or is it allowed with permission? Second, you check the extent to which it's allowed. So sometimes there are sectors where 100% is allowed without permission. Sometimes they regulate it and keep it to 74% without permission. And if you want to do 100% for the balance 26%, you have to go and get consent. So that's, and each of that consent, sometimes each of that investment or sector permission that's given, even the 100% approval that's given, is given subject to certain conditions, which are also set out in the non-debt rules. Essentially, they'll say that, for example, in retail, you'll see that you have to source a bunch of the raw materials locally, etc. So those are conditions that's prescribed by the government. And so long as you meet those conditions, they'll say that, we're going to allow 100% investment into that particular sector. So that's one thing that whoever is trying to read and understand a subscription agreement should make sure that they check that box on which sector does the company which is receiving the investment fall into, and if that investment is allowed automatically, or is it under the consent route. And if it's allowed automatically, to what extent is it allowed automatically? Is it 100%? Is it 74%? Is it 25%? What is it? The second thing is pricing guidelines. This is the second concept. So essentially what the government is trying to do is they're trying to say that if money is coming to the company, you cannot issue it at a very low price. Okay. So what they do is they prescribed a requirement which says that you have to get a valuation done either by a merchant banker, or you have to get it done from a CA, who will certify and say that this is the valuation of the company and this is the price per share of the company, and that's called fair market value essentially. So you cannot issue shares below fair market value. This is to non-residents, right? Even to residents, the same rule will apply, and there are income tax provisions that will get attracted if there's an issue with valuation, etc. But under the Income Tax Act, I think the valuation has to be done by a merchant banker only. So if you have a combination of both residents and non-residents, you'll have to get the valuation exercise done by a merchant banker. If you have just a non-resident investing to the company, you can still do it with a CA certificate, which is most common for most companies. So that's basically the pricing guideline. And the valuation exercise is basically done to simply, as a concept, it's done to arrive at a price per share. Basically valuing the company and saying that this is a price per share that you can give, and that's market value for that particular company. And the third concept is some reporting requirements. So naturally, if they've allowed investment into the company, how does the government keep track of it? They'll keep track of it only if the company is able to report back to them and say, this is an investment that's happened in my company, I'm reporting it, right? So there are some reporting requirements. There's an annual reporting requirement, and there's also a reporting requirement that applies every time an investment is made. And we'll speak about that a little more in the next slide. So this is basically, in short, the regulatory framework that governs subscription of shares. I'm just going to pause for another second or two to take any questions immediately that come off this slide. Otherwise, I'll just move to the next slide.
Amrita, we will take the question at the end. Otherwise, okay, the entire this thing will be spoiled.
Okay.
So they can just jot down the question, or they can post it at the chat box at around 4:40.
All right. So then I'm just going to move on.
Yeah.
This is basically key concepts to a share subscription agreement. I'm just going to lay it all out and then explain each concept. So any agreement, right? Whenever you approach, this is mostly for students, for young professionals. Sometimes reading like a 100-page document can be tiresome, and you don't understand what to focus on, what not to focus on. How do you go about reading it? So what I usually like doing is you break the agreement into parts. Any agreement, you can take any commercial agreement, and the same principle applies. You can break it down into 4 large buckets, okay, broad buckets. The first one is basics. The second is commercial terms. The third will be remedies, and the fourth will be boilerplates. Now, once you break it down into these 4 sort of concepts, then there'll be particular clauses that fall within the ambit of one of these buckets. So what I've done here is, in this slide, I've tried to describe in the concept of in the context of a share subscription agreement. So let's take the basics first. In the basics, there are about 5 broad things that you'll have to generally remember. One is the payment of stamp duty. Okay, every agreement, if it's an agreement in writing, it is subject to a stamp duty payment, and that differs from state to state. And that's because it's a state subject. And share subscription agreement is no exception. So you'll have an entry under the Stamp Act, and you'll have to basically read that particular entry and figure out what the stamp duty for that particular agreement is. What happens if you don't pay stamp duty? If you don't pay stamp duty, it affects your enforcement. It cannot be sort of presented as evidence in a court of law. And of course, the provisions later on paying penalty, etc. But to avoid the hassle, it's better to pay stamp duty first. And stamp duty is usually paid before execution happens. So once execution happens, usually the stamping authority will not sort of entertain requests for stamping. The second thing is every agreement will begin with the introduction of parties. Okay, the purpose and you should always, what I'm going to tell you is what is the purpose of each of these clauses, and then you can, and the nuances that come with it, and then so that it helps you while you review, or it makes reading better. The purpose of the introduction of parties clause is to basically set out who are the parties that are entering into this contract or that particular agreement, right? And it's a basic description which describes that particular party. For example, if it's a company, it will say so-and-so company incorporated under the Companies Act, having its registered office at so-and-so place. If it's an individual, you'll either identify that individual through a PAN number or date of birth. Sometimes it's even archaic, people write father's name and etc. These days, mostly it's either date of birth, or you use a PAN or a passport number as an identification, and you put out your address. So, and that's the whole purpose of introduction of parties. It's just to basically set out who are the parties that are entering into the contract. The third aspect is a preamble. Just after the introduction of parties, you would have seen language which starts whereas, right? That's called the preamble or the recitals. The purpose of a preamble or a recital is basically to set out key facts or the circumstances or the reasons for which the parties are entering into the agreement. It's nothing more than that. You don't have to write any theory there. So for example, in a share subscription agreement, you will basically say that you will describe the business of the company, because I said that the business of the company is relevant from the perspective of identifying which sector the company falls under. You will describe the authorized share capital of the company, which is a statement of fact. You will say that this is the authorized share capital and so-and-so shares exist as of now. And you will say that so-and-so investor wants to make an investment into the company and is willing to invest so-and-so amount on the terms and subject to the conditions set out in this document. That's all is the purpose of a preamble. It has to be crisp, succinct, and it has to basically set out the facts, key facts that you want to capture there. And this you can get a little more creative in more complex agreements and put out facts that you want to document in the preamble, but it should only be a statement of facts, nothing more. Then typically you have the definition clause. It runs into pages in contracts like share subscription agreement. Most of them will be standard definitions. And as you start reviewing agreements, you'll get familiar with what to catch in those definitions, what not to catch in the definitions, okay? Some people also have running definitions, as in they don't have a separate clause in definition, they just go about documenting the definition as part of, when they write the contract in itself, in the body of the contract. That is also fine. It's just a preference that the person who's drafting the contract has. And finally, you have a signature block, right? Nowadays, with a lot of people exchanging signature pages electronically, people usually forget to get signed signatures. So this is something that I wanted to put out there and make sure that you should also make sure that you tick the box on that to make sure that your contracts and agreements are basically signed correctly and executed properly by the respective. If it's a company, it will be an authorized signatory for the company. If it's just a normal person, if it's an individual, the individual sign on behalf of himself. So that's basically your basic bucket. The second bucket is your bucket on commercial terms. Now, after you set out these basics, typically the clause will go on to say, in the subscription agreement, it will go on to say, what is, what are you subscribing to and what is the consideration? So you will say that so-and-so person is investing so-and-so amount and is getting so-and-so shares or this much shares, and he's going to pay so much money for it. Okay, and obviously it'll be subject to because every investment is made based on certain representation, warranties, and covenants that are provided by either the company or the promoters or both. Okay, so that's one. The second key commercial term the second key concept you have to keep in mind is in an SHA you will see 2 or 3 clauses on conditions. And there are two concepts here. One is condition precedent, and there is a long stop date, the concept of a long stop date. And then there is condition subsequent. Okay, condition precedent, as it means, is basically conditions that need to be fulfilled by the company before the investment come in. So it precedes the investment, and whatever conditions the investor requires the company to satisfy before the investment comes in, that is what is categorized as condition precedent. Now, why do we need this? So sometimes there are waivers, etc., that you need from shareholders to enable the investor to invest in the company. Sometimes the investor, most times, almost always, the investor does an due diligence of the company, figures out. Due diligence exercise is basically an exercise that is done to check the health of the company, to see if they're generally compliant, if there are any issues, etc. Because this ultimately affects the valuation of the company, right? So they figure out from the due diligence exercise. And if there are any correctional, there are any items that they want to correct. For example, there's most companies will not have 1 or 2 labor-related compliances, or they'll be non-compliant on something, right? So they'll say fix it, okay, and they'll give you some time limit to fix it. So it's essentially those kind of things that get categorized as condition precedent, and there'll be some requirements under the law. For example, before you issue shares, you will need to have the investor, you need to prep for, you need to, first of all, you need a board resolution to basically authorize the issuance. And then so that you can send the PAS-4 form to the investor. The investor can accept that offer, etc. So basically, whatever you require to prep or to make sure that the shares are issued on a particular day, that will get categorized as conditions precedent, together with any item that is identified from a diligence exercise that needs to be remedied. The other thing is you'll find something that says that you'll have to get a valuation certificate as well, because that's something that's important, that's a requirement under the law. That also gets categorized as a CP. Long stop date is basically a date within which the company has to satisfy the CPs. Okay, so basically, if you have 10 conditions to finish, the investor will say finish it within, let's say, 30 days or 60 days from today, from the day we sign the agreement. And that is called the long stop date. So essentially, it's a date, it signifies a date within which the conditions have to be completed. And if you don't complete it, then investor has an option to either terminate the agreement and not make the investment, or to extend that date. So that's how it works. The other concept is, let me take closing first, and then I'll go to condition subsequent, because there's a sequence to it. Now, once the condition precedent is satisfied, okay, all the conditions that you've set out as CPs are satisfied, the investor will take a look at what you've done. And if they think that, whatever you've done is okay, if they're satisfied with it, they'll say, okay, fine, you will send a CP confirmation certificate. You will say that I've completed, the company will say that I've completed so-and-so CPs and issue it to the investor. The investor will read the CP confirmation certificate and depending on its satisfaction, will say, okay, fine, I'm now willing to make an investment. I'm now willing to invest in your company, and I'll be able to do it within 3 days or 4 days or 5 days or whatever number of days that is. So closing as a concept basically means the day on which the money hits the bank account from the investor, the day on which the money hits the bank account of the company. So the day the investor pays the company money, okay? And against that money, the day on which the company issues shares. So typically a closing clause, you will see all the action items that you're required that are required to be carried out under Companies Act to complete the issuance of shares. And it almost always starts with the money hitting the bank account. So as soon as the money comes to the bank account, the board meeting will be called, followed by the shareholders meeting. And then you'll also have some forms and etc. that need to be filed. The filings will be made. Mostly it happens simultaneously. Sometimes it can happen over a period of 2 days. If you're well prepared, it can happen within a period of 1 day. So that's how, that's essentially closing. The day on which the money hits the account, and against that money, the day shares are issued. So sometimes there is share certificates, because the share certificates needs to be stamped, etc. And depending on the stamping rules in different states, there's a delay in sort of issuing the share certificate. It can take a day or two longer than expected. And so usually closing date is a day on which all the action items are completed. You'll put out saying that XYZ things need to be completed, the board meeting, the shareholder meeting, share certificates. So the day on which everything is completed, that day is then considered the closing date. Okay. So that's the concept of closing. Now, once you've issued the shares, you have to make some filings. You have to make filings. If it's a non-resident investor, you'll have to file and report to the RBI. If it's a resident, you'll just do filing to the ROC. So those action items are basically condition subsequent. All the filings will move to condition subsequent. Sometimes there'll also be items that from the diligence that come out, which require a lot of time to complete and cannot be completed as CP. Because the time period is typically short. So those are moved into the condition subsequent bucket. So essentially, that's the concept of condition subsequent. Then the other concept is something that's called a standstill provision. A standstill provision basically means that now the way a shareholder agreement works is, share subscription agreement works is, today somebody will sign the share subscription agreement. Okay. From today, this is the execution date. So the day the agreement is signed, that's called the execution date. The day closing happens, it's called the closing date. Okay. And the day CPs, the day CPs are completed and the day the certificate is issued, it's called the CP completion date. That's usually it's within the long stop date, right? So essentially what happens is from the time the investor signs the agreement till the time the money comes in, the investor has no rights inside the company because the money, he hasn't put in the money. They haven't put in the money, but at the same time, they've said that, I valued your company. I don't want you to do XYZ. I don't want you to do some actions without my consent, which will affect my valuation. Okay. So those action items are categorized as standstill provision. Essentially, you will say that the company or the promoters cannot take the following actions without the prior consent of the investor for the period between the date of execution and the closing date. Okay. It's essentially a protection provision for the investor to make sure that nothing happens in the company or suddenly you don't raise debt or you sort of encumber the assets of the company because they would have done the diligence and they would have figured out that there's no encumbrance and they would have given a certain value to the company based on the diligence. They don't want the promoter of the company to alter that position in that short period of time. And that's why they'll have a list of things that the company and the promoter cannot do without the consent of the investor. And that's called the standstill provisions. And that gets usually negotiated down, and there are arguments for both, keeping such provisions and for removing such provisions as well. The other concept is reps and warranties. So here you'll have to, every investment is made on certain, based on certain representation and warranties. And this is flowing directly from the Contracts Act. So a representation basically is nothing but a statement of fact. Okay. So let's say I say that the shares are unencumbered. That's a statement of fact. That the authorized share capital is rupees so and so. That's a statement of fact. So that's a representation. A warranty is basically an express or implied promise that is made in furtherance of a contract and is guaranteed by one of the contracting parties, right? So sometimes it's forward-looking in the sense that you say, I warrant you that shares will be issued free and clear of any title issues or without any encumbrance on them. It's more in the nature of a warranty. Now, why is it important? It's important because the remedies for breach under law are different for breach of warranty and for misrepresentation. And that's regulated under the Contracts Act. Okay, so for example, and the other thing also you should remember, the things that get sort of negotiated over here is who provides this representation and warranties. In the US and more in other jurisdictions, because the money is coming to the company, the investor and the promoter say that the company will provide the warranties, which means your remedies will be against the company. If there's a misrepresentation or if there is a breach of the warranty, you can sue the company, but you can't sue the promoter in his or her personal capacity. In India, however, it's very common in early stage investments for both the company and the promoter to back or to provide these representation and warranties. Usually, these reps and warranties run into 40 pages or so, and it covers every aspect of the company's business. You'll have representation warranties on the capitalization. You'll have on the cap table. You'll have representation and warranties on the shares that have been issued. You'll have reps and warranties on the operations of the company. You'll have reps and warranties on regulatory compliances, on encumbrances, the different heads. And usually everything under the sun is covered here, because the investor is saying that, yes, I've done my diligence, but I also wanted to say that these things are correct, are true and correct. That's the purpose of a rep and warranty. And it's usually provided as of the date of execution, and it's repeated again as of the date of closing, because as in the day when the investor signs the agreement, he wants to know that a certain set of facts are true and correct. And when the investor puts in the money, he also wants to make sure that the same set of facts remain correct and are not altered, which is why it's repeated on 2 different dates. That's the concept of a rep and warranty. And those of you who want to do a deep dive into it should actually go back and check the different, the variance in remedies for a representation and warranty. I mean, if it's a misrepresentation, what happens? If it's a breach of warranty, what happens? Now, the other important thing is, okay, they've given a representation and there's a warranty. So what happens if there's a breach, right? So that comes under the remedies clause, and I'll take it under the remedies bucket. So there are covenants that we need to talk about under the remedies bucket. The other concept under commercial terms is basically something that's called a disclosure letter. This is associated with the reps and warranties. Basically, a disclosure letter is, so supposing the reps and warranties are usually very voluminous, and it runs into at least anywhere upward of 20 pages. Okay, sometimes it go into 30, 40 pages of reps and warranties in itself, because there's so many aspects that are covered, and they're usually standard set that's given to you by the investor. So obviously, because it's a standard set, companies may say certain things apply to me or certain things do not apply to me, or some statements are not true. Okay, I want to tell you that if you're telling me that there are no encumbrances, I have to tell you that there is an encumbrance, right? So that is typically purpose of a disclosure letter. Disclosure letter basically makes disclosures against a particular representation. So if the representation reads that there are no encumbrances on any of the assets of the company, and if in fact there is an encumbrance by way of a loan or anything, then you will prepare the company will prepare a disclosure letter and will set out the warranty on a rep or a warranty on the left side. On the right side, it'll say this warranty is true, but I have a loan or whatever encumbrance on my asset. So all the exceptions to a warranty or a representation gets covered in a disclosure letter, and that's usually provided as of the closing date. And the investor basically generally are mostly comfortable if those are the standard things that have come up, and they're aware of it as part of the diligence. If there's something new that comes up between the period of execution and closing date, that's when people get a little nervous and they start negotiating, and their indemnities or something that's done to either provide for it, or the investor, if they're not comfortable, they will terminate the agreement in that sense. That's the purpose of a disclosure letter. And the last thing you need to remember is pre and post closing capitalization tables. A capitalization table, or a cap table as it is called, is essentially a table that shows who are the shareholders of the company, which shareholder holds how many shares. Okay, so it's usually put out as a schedule in the share subscription agreement. And there'll be a cap table that is before the investor comes in, before the investor is issued shares, and there'll be a cap table after the investor is issued shares. So that's the pre and post closing capitalization table. That's a concept of capitalization table. It's always useful for lawyers to also understand the math of working, how a cap table is created, generated. It's usually linked to the pre-money valuation and the shares, etc. And it's always good for lawyers to know how to actually work their way through or understand a cap table. I'm going to move to the next bucket, which is basically the bucket on remedies. Now, we spoke about representation warranties, we spoke about disclosure letter, etc. So what happens if there is something that, let's say, I'm the promoter or I'm the company, right? I mean, I've said all these things. I actually end up misrepresenting to the company or making a fraudulent representation. What remedies does the investor have? So that's what is covered under the remedies clause. And essentially, you'll have something that's called, very commonly called, indemnity, which is there in every contract. An indemnity is a concept that flows out of the Contracts Act. It's essentially a contract. It's called a contract of indemnity. It's where one person agrees to indemnify the other for certain actions, right? And if you read sections 124 and 125 of the Contract Act, you will also figure out what is it that you can recover as part of indemnity, etc. So this is a heavily negotiated in an SSA. I think it's reps and warranties and indemnity that's heavily negotiated on both sides. Essentially, to claim an indemnity, the investor has to prove a loss. That's the concept. So it's basically a compensation for a loss suffered by the investor because there has been a breach of warranty or there's been a misrepresentation by the promoter or the company or whoever is providing the representation and warranties. So long as they show a loss that is arising, first they show a misrepresentation or a breach of warranty. And the minute they show that and they show a loss arising from there, they'll be able to claim an indemnity. And typically, there are some caps that apply on indemnity. These are more contractual agreements. People usually like to cap it to the amount that's invested, unless it's an event of fraud, because fraud is uncapped. And there's certain exceptions where, for example, title-related stuff is always uncapped. Any misrepresentation on title is uncapped. Otherwise, all the business warranties, etc., are capped to 1x, which is a subscription amount. Sometimes there's also a cap on the period within which you can actually make an indemnity claim. So typically it's 3 years for business warranties and about 7 to 8 years for tax warranties. And for title-related stuff, it's usually uncapped and it's under the law. The question really for lawyers is, can you trump a statutory right by way of a contractual agreement? That's something that is something that you need to consider and keep at the back of your mind when you draft these provisions. That's the limitation of liability clause. There's also limitation of liability in terms of sometimes you'll say that the remedies are exclusive or you'll say that the remedies are cumulative. These are basically exclusive remedies, basically mean that whatever remedies is provided in the agreement and set out in the agreement, those are the only remedies that the investor will have in the event there's a breach or there's a misrepresentation. And cumulative basically means that in addition to what is set out, in addition to indemnity or specific performance or whatever it is that you set out in the document, they'll also have the remedies available to them under law. For example, damages is available under law. The other point that you should remember here is, why do people, first of all, put an indemnity? Why is it a contract of indemnity when there's a clause or there's a statutory remedy available in the form of damages under 73, 74, right? The reason for that is simple, is because 73, 74 is a statutory right, and the threshold for the stuff that you have to prove to be able to get damages is slightly higher, whereas indemnity is a contractual right. So you're free to write it out and decide how it will be enforced, what you need to prove, etc. So there's more flexibility, and that's why people like including indemnities in a contract. This is a general concept. The other type of remedies is basically specific performance, essentially in form of injunction, etc. If people don't issue shares or if there's something that happens, very rarely gets invoked in a share subscription agreement. And a couple of things that you have to also remember is the governing law and the dispute resolution provision. It's always governing law for Indian company, and usually when there's investment into India is always Indian law. Dispute resolution is basically the arbitration provision. A lot of people provide for two things. They provide the arbitration mechanism and under which rules the arbitration will basically be carried out, and they also set out the jurisdiction of courts. These days, a lot of investors prefer SIAC because basically it's a very smooth process in terms of arbitration. So a lot of arbitration, it's usually a single arbitrator because it's cost efficient, and SIAC, and the seat is also Singapore. Indian promoters, very rarely, Indian promoters, of course, prefer Indian arbitration, but the general trend in VC documents is towards arbitration outside of India, mostly SIAC and other sort of jurisdictions. So that's and the last thing you need to remember is your termination clause and your consequences of termination. I put this as a remedy because there is a similar concept under Contract Act, which basically is called rescinding a contract, right? And that's specifically available where there is breach of a condition or a warranty that's so essential or fundamental to the contract that the contract cannot sustain in light of that breach, and that's when you get the right to rescind. So termination is again a very contractual concept. It's basically the right given to the investor or a party to a contract and it sets out the circumstances under which termination can be carried out. Under when can you terminate the agreement? So in an SSA, the key to remember is usually termination provisions are all pre-closing. That means it has to, if somebody has to terminate, they have to terminate before closing happens, because once shares are issued, what will you terminate, right? I mean, there's nothing to terminate. You have to reverse the whole thing. So usually the termination provision is something that's always pre-closing, and before the closing happens. And so it's basically till the time closing happens, the investor has to make sure that he or she or it is absolutely sort of certain that they want to invest in the company. There's no breach. They have to satisfy themselves. So typical termination clauses are drafted along the lines of breach mostly. So if there's a breach that cannot be remedied of a covenant or a representation or a warranty that cannot be remedied, the investor has a right to terminate the agreement. And usually there's a cure period also that's provided. Usually the other side is provided a cure period of 30 days or 10 days. That's something that's negotiated. And if that doesn't happen, then the agreement sort of terminates. And consequences of termination is something that's it's sometimes neglected in a document, but that's something that you should clearly check and see what happens in a termination when the agreement terminates, right? Basically, the investor's right to subscribe will fall away. Will there be any remedies they have? Can they sue you for damages because you didn't perform your part of the contract? There's some things that survive termination. Typically, indemnities, etc., survive any termination of any contract generally. Which means that even if the agreement terminates, so there's a breach and the agreement terminates, and the investor only terminates the agreement, the investor still has a right to go after, if they think so, to go after the promoter, etc., for that particular breach. It's a rarity in VC contracts, because the VC contracts, venture capital as an ecosystem works on relationships and between the venture capital investor, the funds, and the promoters, and it's a very sensitive relationship. And nobody, from an investor perspective, nobody wants to be seen as somebody who goes after companies for petty things, right? So unless something major happens, venture capital deals usually do not see a lot of disputes, because the key is to resolve them intelligently and commercially, so that both the parties sort of make their peace and move on, rather than there being a lot of bad blood. Unless, of course, there's something like fraud or something that's involved, which you will have to take some action against. So that's basically summarizing your remedies buckets. The final one, and the most neglected probably in an agreement, is the boilerplates. Boilerplates are basically miscellaneous clauses, or clauses that a lot of people think is inconsequential, but it's very, very relevant when it comes to a dispute. For example, notices clause, the way you draft your notices clause will determine if how you serve notice for a dispute, etc. The same thing is on rules and interpretation. Confidentiality again, because a lot of people make the agreement itself subject to confidentiality obligations without providing an exception, saying that in the event of enforcement, the confidentiality obligation will fall off. So there's some nuances that are there around these provisions that basically should be kept in mind, especially keeping in mind the enforcement side of these contracts. So typical boilerplates would be key boilerplates would be confidentiality clauses, where each party agrees to maintain confidentiality about the negotiations that have happened, about certain sensitive information that's been exchanged, etc. Notices, basically, how do you send notice, the method in which you send it, whether you do it through emails, whether you do it through courier, do it through fax. So it's very important, therefore, to also provide for emails, etc., so that it's easier to send notices to people. It also sets out the addresses to which it needs to be sent out, and sets out an obligation on people to basically notify the other person if there's a change in address, etc. Very practical need for this clause. Then there's assignment provisions. Basically, if any party in the contract is allowed to assign their rights under that particular contract to somebody else. So you typically capture that in the assignment clause. This is very relevant. This is relevant for investors if they haven't determined the vehicle through which or who will be the shareholder in the company, right? So usually funds are structured as the multiple vehicles within a fund that will probably invest. So sometimes if they haven't made up their mind on who will make that investment, or which particular vehicle will make that investment, it becomes relevant to them at that point in time. Amendments is again a standard clause that basically sets out when an amendment will be made, how will it be made, does it have to be made in writing, etc. Standard, straightforward. rules and interpretation is something that lawyers like to put in. And I would advise every lawyer to actually think through carefully, because people usually do a cut, copy, paste job here. And sometimes there are things here which affect your enforcement. For example, very classic case example is the use of and or, and the rules of interpretation around it. And there's also on including without limitation, because a lot of times people write in the interpretation that every time you say the word including, it means including without limitation. And generally, grammatically, people, when they want to cover a lot of things, they use the word, inadvertently use including and the definition or something, and that could then be interpreted otherwise. So you have to be careful about what you set out in the rules. And finally, cost and expenses. This is very unique to a VC deal, because the investor usually, the company reimburses the investor for the costs that the investor has undertaken as part of his diligence exercise, etc. And that cost is also usually put out in a VC or in a subscription document. So this essentially sums up the SSA. Those are the concepts in an SSA, and I'm happy to take any questions that anyone has on any of these things.
Yeah, this is by Anubhav. He says loan agreement can also be said so, but I guess there is more to it. What is the take on that?
Sorry, what is the question again?
He says the loan agreement also has certain these points only. What is your take on that?
See, a loan agreement is very different from a subscription agreement. A subscription agreement is not a debt. A loan is a debt. As I mentioned, venture capital investors never do. Yeah. Please explain your question. I think he needs to be unmuted.
Yeah, I will unmute him. That's not the issue. In fact, Anubhav, in fact, anybody who wants to get himself unmuted, we can do that. Meanwhile, Srinivas says, can venture capitalists investment through public issue?
No, it's typically, see, that's a separate leg of venture. I mean, there are different types of investors. So that those are usually portfolio investors, foreign portfolio investors, and that's regulated separately under the different categories of investors. To answer that question, I think that's the elegant way to put it. And people who usually invest in stock markets or through stock exchanges, etc., are a separate category. Not necessarily, they're not traditional VCs. VC will do a direct investment into a company by way of subscription to shares.
Hello.
Yes.
Yeah, so ma'am, I have written 4-5 questions with me. So these are pertaining to various concepts you discussed throughout the session. So should I go in a chronological order?
Yeah, sure.
So ma'am, is it necessary for a company to, in order to give returns to investors, to go public?
IPO is one of the exit mechanisms that's provided. You are right. So when an investor has to exit the company, right? There are 2 or 3 ways in which exit happens. One is IPO, where they take the company public and they list the company, and that's when the investor also gets an exit. And that really depends. I mean, IPOs are not very common in India because it really depends on what the environment is, whether it's conducive, whether it'll get listed and you'll get a good return, whatever, etc. Right? The most common way is for one institutional investor to sell it off, either to another institutional guy, a bigger PE player, or to the promoter, or by way of company buyback. And that's when they make their exit, so it's either through secondary sale to individuals or by way of going public, IPO. Yes.
All right, understood. And ma'am, can you give us some examples when a company go for Series B investment, other than obviously introduction of a product line or expansion, other than the generic one?
So the general concept is the life cycle of a fundraise is about 12 to 18 months. Okay. And it depends on how capital intensive the company is, or how much of cash burn the company has. For example, if you're in the logistics sectors, there's a heavy investment, right? There's a lot of money that keeps getting burnt, and you need a lot of you have a lot of operating expenses. So essentially, the decision to when you want to raise the next round of funding happens at the time when you're out of money. So, and that's usually a 12 to 18 month cycle. So if somebody has raised Series A in the last 12 months or 18 months, it's most likely that they'll do a Series B investment, because that's a typical cycle within which you would have burnt out all the cash and you need more money into the company.
Understood, ma'am. And what's the difference between recitals and preamble? Like I understood what you told me preamble, but yesterday I attended a
Okay.
webinar in which they were.
It's the same thing. It's just a different nomenclature. Preamble and the recital serve the same purpose, and it's exactly the same thing as a concept.
All right. So they basically give context to the agreement.
Context of the agreement, and also the purpose is to set out key facts, right? So sometimes, I mean, not in the context of an SSA, but say there's a settlement agreement that you're entering into, right? You may want to put out some key facts there and record it as part of your preamble. So that preamble can be used for that purpose as well. It's basically, it's a golden opportunity for people to set out key facts and get both the parties to sign off to it. Yes, somebody has asked me a question on whether recitals are binding. Yes, and so the Supreme Court, there's a Supreme Court judgment on this, and sometimes even lawyers usually put out a clause saying that recitals are binding, at the end of the recitals. But it would be, because it's part of the agreement and it's considered as part of the agreement, and the agreement is essentially signed off as a whole, right? So it would be binding.
Understood. Ma'am, another question is, you at one point of time you mentioned that whether contracts can overshadow the statute. So can you elaborate a bit on that more?
Yeah, so I think this is something that needs like a larger discussion. But the point I was trying to make is, look, contractually you agree to a bunch of things, right? When you're saying that under the act, under the law, for example, there is the right to receive damages. There's also a limitation period, right? The law itself prescribes a limitation period. But sometimes people put a shorter limitation period and agree to it contractually. So you say that if the limitation period under the law is 3 years, contractually you say, a lot of lawyers say, okay, let's make it 2 years under the agreement. The question then arises whether you can actually waive away a statutory right. Okay, and this is something that you can debate, and it probably needs to be tested in a court of law, and also probably before an arbitrator. And it'll be interesting to see how that sort of progresses.
Understood. And
my personal view is that you can't really trump a statutory, right in that sense. You can probably cover it to the extent and say that this is a commercial understanding, and that remains to be tested and seen if that can be enforced as an argument. But it'll be interesting to see how that progresses.
So it's in limbo. All right. Yeah, all right. So can we? Another question is, can we put force majeure clauses under boilerplate?
You can put force majeure, but it has very little utility in terms of a share subscription agreement. A force majeure would be more relevant in a commercial contract. For example, if there's a supply contract, or if there's something that needs to be distributed, where there's an action that needs to be taken, right? And something prevents you from taking that action. In a share subscription agreement, it's very, very, it's a sort of a redundant sort of a clause to have, because there's very little utility for it. Because everything is set, right? I mean, the investor will say, I'll pay money on so-and-so date, or within such and so-and-so period. On that particular day, you're supposed to do XYZ things. And if you don't do it, the investor will probably give you an extension or will terminate the agreement. So really, there's very little utility for a force majeure clause.
Understood. And this is my last question. Sorry for taking so long.
No, that's okay.
Yeah. Can you please explain the assignment part under boilerplates?
Yeah. Okay. So assignment is basically a concept under the Contract Act, which allows a party to a contract to assign the right it has under the contract to someone else. So let's take it I'll break it down for you in the context of a share subscription agreement, since we're on it. So in a share subscription agreement, basically investor has the right to subscribe to the shares, right? That's a right given to the investor. And the party that enters into the agreement, now let's say I'm an investor and I have 2 vehicles or 2 companies through which I can invest, okay? One of the companies is basically a party to the agreement, and I want to assign this right of investing to the other company for some reason later on, okay? Similarly, like that, you can take out the right to be indemnified, right? That you can take out specific rights into the agreement and give it to somebody else. That's the concept of an assignment.
All right, thank you so much. The explanation was really helpful and very elucidative. So thank you so much, ma'am.
I saw a bunch of questions that came on the chat box over here. There are at least 55. It'll take me a while to go through all of it.
I will read the questions for you.
Yeah.
Because not all are the questions, because some have praised about the session, and Some have just also elaborated on their perspective. So they're not 55 question as such.
Okay.
This is by Pratyush. Can an agreement provide for both liquidated damages and indemnity clause? Damages for breach of the agreement and indemnity against any claims raised against it.
Okay, so yes, you can. So here is how it will work. Liquidated damages is basically, as a concept, means that you'll have to set out a particular amount that you think is a good estimate of the damage that you're likely going to incur, right? And you basically say that this is the amount that I'm going to most likely incur. So it's a preconceived or preset amount that's put out as liquidated damages. And the concept, and if you look at commentaries, if you read commentary on Mullah, etc., once you do liquidated damages, you have no other, you have to stick to just that as a concept. Nobody will give you another right to, again, then indemnify, because that's compensating you overtly, right? Which is why it's not very popular with a lot of people, because a lot of people don't have an estimate beforehand on what kind of damages they'll actually end up incurring. Only if you have that kind of estimate will you actually put out a liquidated damages clause. Enforcement of liquidated damages clause is very, very simple, because it's a straightforward compensation. You don't have to determine or prove any loss, etc. You just have to show that so-and-so event has happened and I'm supposed to get compensated because so-and-so has happened in X amount. So that's the benefit of having a liquidated damages clause. But the other thing is, if you have no estimate of the kind of losses that you're going to or most likely going to incur, then you shouldn't be doing it. You'd rather just sit with an indemnity and sort of draft that as a clause. So it's like, I think it's circumstantial. You should decide depending on whether you have an estimate or whether you don't have an estimate.
Taking further, Srinivas Reddy says, can you please elaborate on indemnity versus damages? That is under section 73 and 74 of the Contract Act.
Correct. So the first key thing as a concept, the key thing you need to remember is damages is a statutory right under 74. Okay, it's basically a right that allows you to claim certain amount of damages if there's a breach, right? Indemnity, on the other hand, is a contractually drafted remedy. It's a contract of indemnity, and it's basically essentially compensating you for a loss. So the threshold for indemnity, what do you need to prove to enforce an indemnity versus what do you need to prove to enforce damages are two different things. For example, if you look at 74, there's also language which says that you cannot claim indirect or remote losses, right, as damages. So then the question is, what is an indirect loss? What is remote? Whereas in a contractually agreed indemnity, you can actually eliminate that. You can say that I can also claim indirect loss because it's contractually agreed. So it provides a lot of flexibility to a lot of people to determine how they want to draft that particular contract. What will they be able to claim? Which is why a lot of people prefer indemnity as a contractual remedy rather than going under the thresholds under the statutory remedy of damages. Does that answer your question? Do you have any other follow-up questions on that?
If you will have, then we can do. Just. Okay. What's the difference between reps and warranties and covenants?
Okay, so this is my favorite question. I keep asking a lot of people who I interview also this question. So a representation is basically a statement of fact. Okay, it's a statement of fact as of today. For example, let's say you're saying my name is Amrita. That's a statement of fact, right? And it's a statement of fact as of today. And I can say, in the context of an SSA, I can say I'm a company that is incorporated on so-and-so date, and this is my authorized share capital as of today. That is a representation. A warranty is basically a promise, okay, in furtherance of a contract that is made by one of the parties to a contract. So it sometimes is forward-looking. For example, you say, I will warrant you that the shares will be issued to you at so-and-so price, and it will be issued free and clear of encumbrances. That's a forward-looking warranty, right? Because it's not issued to you today, but you're guaranteeing that it will be done on a particular date and in a particular manner and without any encumbrances. So that is a warranty. A covenant is something that is an undertaking. For example, an undertaking to indemnify, that is a covenant, okay? And where it makes a difference, one is to understand the concept, how is one different from the other? And the other is to understand what are the remedies associated with breach of each one of these. So under the Contracts Act, the remedies for misrepresentation, the remedies for breach of a warranty, and the remedies for breach of covenant are different. For example, if the covenant is drafted as a condition, okay, like a condition to the investment, like a condition precedent, and that condition is so fundamental that without it, the entire contract will fall away, you actually have a statutory right to terminate, which is not available for misrepresentation, right? Misrepresentation is an option. You can make it, it's voidable, it becomes voidable at the option of the party to whom the misrepresentation is made. The remedies vary. You can also have damages as a remedy for all three. So the remedies also vary accordingly. That's the difference between the three as a concept.
This is by Sudhir Bhatt. Can VC funds invest at a premium through preferential shares at a face value? The premium can come as a share premium.
That's how it's usually done. I'm not sure I understand the question correctly. There's always a face value, and based on the valuation, there's a premium that's paid, and the premium obviously goes and sits in the premium account. That's usually how it's typically done. Is there something more to that question? I'm not very clear about it.
Meanwhile, we are unmuting Riddhi Upadhyay.
Okay.
Hi, ma'am. Am I audible?
Yes, you're audible, Riddhi. Hi.
So, ma'am, I have two questions. Firstly, could you throw some light on the concept of specific indemnities?
Okay. So you've understood the concept of a general indemnity, right? It's basically a contract where one person agrees to indemnify the other for certain breaches or fraud or whatever. You're free to determine in the contract what should under what circumstances you'll be indemnifying the other person. A specific indemnity is something which is specific to a particular event. For example, let's say there is some litigation that's happening in the company, okay? Or there's a tax claim. This tax claim is something that's most common. And the investor is worried that there may not be a favorable ruling in favor of the company. What the investor will do is, in addition to having a general indemnity, they'll have a specific indemnity for that specific aspect, saying that if you lose the claim, then there's a loss that's accrued to me, and I should be indemnified accordingly, right? So specific indemnity is specific to a particular event or circumstance, whereas general one will be very generally saying any type of breach. The specific will specify the type of breach.
Say if that specific event has been captured in the disclosure letter. Say the company is saying that I have this pending litigation or this pending tax matter, then would the indemnity claim still stand?
So the typical way it's done is if the investor is uncomfortable with some disclosure like that, they'll ask you to drop it off and instead give an indemnity. It's not both ways. So once you disclose, you really can't. Once it's then the disclosure letter, the investor already knows about it, right? And they've made a conscious decision to invest. At that time, they can choose to say, I'm investing subject to an indemnity, or I'm investing subject to no indemnity. That's how it works. So sometimes there may be something that they're uncomfortable with which comes as part of disclosure. Then they say, okay, I'm accepting this disclosure, but I want an indemnity for it. And usually it's knocked off in the disclosure schedule so that there's no confusion for anybody. And instead it's captured as an indemnity in the document, as a specific indemnity in the document.
All right, and ma'am, my second question is, say between execution and closing, there's some event that comes up that wasn't captured in the earlier disclosure letter. Like say there's a new litigation that came up between execution and closing. So in this event, what would the approach be? Usually,
you'll provide a disclosure. There's an updated disclosure letter concept.
It's
to cover for a period after signing and before closing. And that's the opportunity that's provided for the promoters and companies to basically make the disclosure. If they don't make it, it will be misrepresentation, or depending on if there's an intention to defraud the investor, it could also even become a fraudulent representation.
Okay, thank you so much.
We have unmuted Shubhang.
Good evening, ma'am. Can you hear me?
Yes, I can hear you. Hi, Shubhana.
Hi, ma'am. So you spoke about how the FEMA regulations provide that the valuation and the pricing has to be fixed according to some criteria. Now, I suppose that the investor would like to quite heavily negotiate this particular limit. So practically speaking, does that become a problem?
Not really. See, the way it works, and the FEMA only says that you have to get a merchant banker or a CA to basically value the company. Right. The only concern that the government authority has there is you don't sell shares at a price that's lower than what it ought to be. And usually, nobody. The valuation exercise So that's from the legal perspective. From the investor's perspective, valuation means a lot of other things. For example, there could be a huge tax litigation or something that affects the valuation of the company, right? Because if that is materialized, then the company will have to pay out from its pocket a certain penalty or whatever, the tax amount or whatever, which will get accounted, which will basically be a consideration for the investor to decide as part of its valuation exercise. So there are two different things. One, the investor also considers these factors, and the basic threshold is you can't go below something that the law says is FMV. And usually it's above that, right? I mean, nobody does it just as FMV. They'll do it a little bit above FMV only. And at that time, the investor will also consider these other external factors to sort of build into its valuation, and accordingly either discount or up the valuation. And it never gets into a tricky situation unless there's a disconnect between the two parties, because the principles are very clear. I mean, if there's something that you know is going to be a likely penalty and it's most likely going to come up in a huge amount, everybody on the table will readily agree that should, there should be a hit then with the valuation of the company, right? So it's more depending on, whether the parties on the same page. I have very rarely seen a disconnect that way, and it's usually resolved directly between the investor and the promoter itself.
All
and
right,
so
ma'am,
long as
thank
you're
you.
fair and logical about it, I think it gets resolved very quickly.
Okay.
This is by Sia. Sometimes in case of a preference shares subscriptions, drafts also have clauses that investor will be entitled to vote at each meeting of the equity shares holders to the extent of such proportion of total voting rights, as the investor could have been entitled, assuming full conversion of all investors, CCPS, as a concept of preference shares don't carry voting rights. Then what's the legal basis for clause? If you want, you can check this question is at 522.
522.
By Siva. Because the question is quite long, I thought that.
Yeah. Okay, I got it. See ya to everyone. Okay. Sometimes in case of preference share subscription, drafts also apply with investor being entitled to vote at meeting. Yes. So, Sia, good question. The way it's, this is exactly the reason why, because they don't want, sometimes investors don't want to get into this interpretation issue, whether they can actually vote on an as converted basis. This is exactly the reason why they subscribe to nominal equity shares. This is what I was trying to even articulate in the point before when I said that it's better for investors to do it nominally. And I've seen this in most of the investors that I've represented usually do it as a combination, and this becomes then redundant. But I've seen this clauses as well. I don't know how. I mean, unless you convert to equity shares, you won't really be entitled to the right to vote at a ordinary meeting. So although it's drafted there, it's better to. The other work around it is to basically make sure that your investor gets both pref and equity.
This is by Nirav. When, how, and what price will be the CCPS be converted into equity?
When and what and at what price? Okay, so it's a very rare, really very rare event for an investor to actually convert the CCPS into equity, because mostly they usually sell off their CCPS. To another to do a secondary sale when they exit, and it's usually sold as CCPS. The only times they probably convert it to equity is when an IPO is probably happening, or where the companies are getting prepped for an IPO, or sometimes if there's a lot of dividend that the company wants to issue out, and they want to, sometimes when there's huge dividends that they're given, the promoters also request for the investors to convert so that they can enable them to more fully sort of issue those dividends generally, and that's when. Those are the only two circumstances I can think of when somebody would actually do this. They would probably convert. This very specific set of circumstances under which they would convert. It's not necessarily convertible. It's just sold off like that in a secondary generally.
This is by Rohit Mansukani. Why not a combination of equity and convertible debt instead of equity and preferential shares? Interest can be paid out capital but not to be divided, and the rights under IBC carry with the debt, and until conversion, the instrument will remain as a debt.
Yeah, because the answer lies in the concept of a debt. Instruments are usually done by venture debt investors. Venture debt is a separate concept from venture capital investment. the two terms itself is a distinction. Right? Venture capital is one thing, venture debt is another thing. And there's separate venture debt firms that do these kind of venture debt deals, the debt deals. And that deal is negotiated completely differently as opposed to a venture capital investment. And a venture debt deal is usually between two series. But most venture capital investors, they invest in the capital of the company, not in the debt of the company. So that's a conceptual difference. And the debt will usually be, that kind of investment will usually be made by a venture debt investor. That's the answer to the question.
How merchant investors / CAs a certain fair share value?
Sorry, I didn't.
How do the merchant investors and CAs invest the fair share value?
How do they arrive at the fair market value? There are different methods to do it. Most common method is discounted cash flow, DCF. So it's a mathematical method that they use to basically arrive at the fair market value.
Next is by Shashidhar. The investor sent excess amount of rupees 20,000 plus in case of FDI, and the bank is insisting on the return of it. Only then RBI is filing single master form of FI RMS portal of RBI can be done. It's pending for more than a year. What is your take on that?
Can you point me to who I want to read?
532 by Shashidhar.
Okay. The investor sent excess amount of rupees 20,000 plus in case of FDI, and the bank is insisting on the return of it. Only then the RBI, it is pending for more than a year, please suggest. Okay. So Shashi, that you have to, I mean, this is problematic in sort of many ways. The option is to return the money, speak to your AD bank and get it done immediately. Since it's pending for about a year, you probably already breached the limitation period that's set out under the FEMA, as well as under the Companies Act, because Companies Act also requires you to issue shares within a particular period of time, failing which it gets classified as a deposit, and then the deposit rules apply. So the best thing to do would be to basically compound the RBI related issue and make sure that you pay whatever interest that needs to be paid on the deposit as well. So you close it and return the money.
We are unmuting Mr. K. Sankaran. He has asked, probably wants to ask a question.
Okay.
Mr. K. Sankaran. You want to ask the question? Yeah. Mr. Sankaran, you will have to unmute yourself. Meanwhile, you can take the question of Vaishnavi with just 1 or 2 equity shares and the rest in the CCPS. Will the investor have enough power to influence the shareholder decisions?
Yeah, that's more than enough. I mean, usually people do 10 equity shares. It's just so that you get those rights that are generally available to ordinary shareholders.
Yeah, Mr. Sankaran. Sankaraman. Mr. Sankaraman. Unmute. Mr. Sankar, yeah. Unmute. You have been unmuted. You can ask the question. Or you can post the question.
Anubhav, in the meantime, I've seen your question. The next session will probably be sometime in November. I'll be talking about the concept under the SHA for a venture deal. And the PPT, why don't you write to me separately? I can send you a copy.
I can share it in the WhatsApp group.
Okay.
Of the Beyond Law CLC.
Okay.
I think he's not been able to do this. Actually, we have no other questions. And thank you to all the participants who have joined us for this session. And Amrita has explained the session in a very erudite manner, the entire session. But
I think there's one more question.
Yeah, that's what I just saw.
Yeah, okay.
As they say, sometimes it's a parting shot.
Yeah, let me just read that question and answer Akash. So Akash is saying 2 questions coming from wanting to understand how regulators look at foreign debt versus equity funding. Do foreign VC funds need to be foreign equity holders in the company to finance via ECBs? are there specific sectors where ECBs are raised but equity investments are not? No. The answer to no, question number 2 is no. There are no spec sectors. And ECB is a separate regulation altogether. The separate rules that apply. Those are distinct from FDI rules that apply to foreign VC funds. And they don't really need to be, ECB, the ECB regulations, if you look at the ECB regulations, you will understand who can actually raise ECBs and who can provide ECBs. So it'll answer your question on 1. That's the straightforward answer under the ECB regulations.
And the second question.
Second question, no. The answer is no. I said that. There are no specific sectors as such.
Thank you to all the participants who have logged in not only on the Facebook, YouTube, and this on this platform, and to Amrita, who has shared the insights. And I'm quite sure that those who have watched us will participate in the second session, and they will spread a word. Thank you to you. And tomorrow, since they are the shadow holidays, we have kept the time an unusual time. Otherwise, we keep it on weekends, on Saturdays at 5 p.m. But tomorrow it is at 1 p.m. Mergers and Schemes of Arrangements, an overview by T.K. Bhaskar, advocate, a partner at HSBC Partners, Chennai. So do stay connected at 1 p.m. Everyone stay safe, stay blessed, and thank you. Have a great